this week and in the next 2 weeks, we will be talking about law and justice. We will also be talking about law revolution and legitimation. I quite remember that we started a discussion on law, order, and justice. But I'm sure we've gone on holiday, and most of us may have forgotten what we discussed that day because of the rice and chicken that we have ate during the holiday. So I'm going to go over what we discussed on that day. I'm going to go over that. When we talk about law, there's so many connotations that comes to us when we talk about law. There's so many connotations that come. And I want us to go back to our legal method class where we discussed definitions of law. And of course, you know so well that we never agreed on a definition because each school that we looked at that time, their perception of law is different. But one thing we need to take out of everything that we discussed about is that law is a rule that is obeyed. I'm not going to say that must be obeyed. That's what Austin told us. But I will say that law is a rule that is obeyed by a collective. And what do I mean by that? I mean a certain percentage of people, a community, they do obey the law. It doesn't mean that when they obey the law, that they like what the law is saying, but they are forced to obey the law because of the dictates of the society. So they are forced to obey the law. So law is that rule that guides and guards our interactions with one another. Law guides and guards our interaction with one another. Now, when we talk about order, what are we talking about? We're talking about a precision, a way things are done. That's what we're talking about. We're talking about with precision. We're talking about laid down rules. We're talking about what we needed to do. A certain way of doing things, a standard, there is a standard that needs to be met. That is order, there is a way, there is a set way that we need to do things. Then, when we talk about justice, that is another very strong word, because justice means different things to different people. Because what is justice to me may not be justice to you. But anyhow, we need to meet, at a certain point when we talk about justice, because we need to have an idea of what the justice is all about. Because if we don't have an idea of what the justice is all about, then we may not be able to do certain things. And we just really need to know what the justice is all about. So when we talk about justice, most times we're talking about a certain expectation. There is an expectation that we demand when we talk about justice. There is an expectation that is demanded of us when we talk about justice. So, for example, Aristotle, Plato, they have an idea of what justice is. For Plato and Aristotle, justice means treating like as like, treating same as same. That is the way you treat a man, whether he's wealthy or not, is the way you should treat a man that is unwealthy. But I need to give us a caveat here. And the caveat is, you find out most times when you're reading your text, which I believe you're reading, you find that in those times, those philosophers did not have a good view of women and children. So when we're talking about justice, justice does not include women and children and slaves, because slavery was accepted. Slavery was accepted. And so if a man mistreats his slave, nobody's going to say anything about it. It's like, it's the norm, when a slave is being mistreated, nobody takes it as anything. So if we are going to be looking at that order of justice, then we're also going to be doing a measure of injustice. Because if we agree that all humans deserve justice, then it means that we need to make sure that this justice is what is acceptable to everyone. Now, I have tried to look at each of those concepts one after the other. Now, we need to take them together: law, order, and justice. And what do we mean by that? We have established what law is. It is a rule. It is an accepted behavior in a society. It is a conduct that is expected of everyone within that community. There is a certain conduct that is expected of them. That's law. Now, when we talk about order, we're talking now a precision, a way of doing things. And then we talk about justice, and we say this, in essence, is that we need to treat like as like. When we're considering anything, we need to treat like as like. Now, all this, because we're dealing with concepts, but these concepts are not standing on their own. They are expected to stand within the purview of the society. So so law, order, and justice are operating within a society. And if that society does not have law, or does not have order, then what exactly do we expect, or are we expecting, or what will be our expectation? Now, as students of law, one of the things that we seek to do is that we seek that justice be done. So that's one of the things that we seek to do, that justice be done. And we can only measure that squarely on the heels of law. If we want justice to be done, it can only be measured, by law. So all we need to do is to look at the society we're in. And when we look at that society that we're in, it affords us to be able to gauge, because we look at the society, and when we look at the society, what do we see? We see a society that most times it is fractured. We look, most times the society is fractured. You look at a society, and there's so many expectations of us when we're talking about society. There's so many expectation. A lot of us, we desire expectations. But the expectations that we have of society can only be dependent on order. If there is a law that nobody keeps, then we haven't succeeded. That's what it means. If there is a law that we have not succeeded at all in any way, and for us to be able to succeed, we need to follow order. And it is the order in the society that can lead to justice. As a law student, there are rudiments that you know. The first rudiment is that the Constitution is the ground norm in the society. The Constitution is the ground norm. Then, beside the Constitution, there are other laws. There is the criminal law, there is the Sale of Goods Act, there is evidence law. So these structures, in a way, form order in the society. And because the structure form order in the society, when there is an infraction, and there is going to be an infraction, when there's an infraction, there is now something to measure up. Because the law is situated, we already know, there is orderliness in the society, there is a way of behavior, there is a precision, there is a standard, a common standard. And so when there is a fraction, then we demand justice. But in our demand for justice, we will find out that in our demand for justice, that certain forces do play. certain forces do play when we demand for justice. And so, as a law student, the question I want to leave you with this morning, before I move on, is, can law uphold justice? Can law uphold justice? I want you to ruminate on it. It's not a CA question or anything, but because you're a student of law, these are things that you need to interrogate. Can law uphold justice? And if law can uphold justice, to what an extent? So these are things, these are discussion you can have with one another, if you had studied. Because of our time, let me just go to justice as an extra legal standard. Justice is an extra legal standard because it makes a demand. It makes a demand on the society. Justice makes a demand on the society. And what is that demand? You find that when things happen, and let me start with the story of Mr. Blackburn. I don't know if you've ever heard about him. Mr. Blackburn was an Englishman that had 2 daughters, and that was very, very, how do I put it? He was very, very interested in his society, and he was very, very interested in law, So for Mr. Blackburn, when a new law comes into place in the society, even though he's not a lawyer, he tries to read the law and wants to know, the mischief behind the law. Because when you see a law, for example, the Anti-Same-Sex Marriage Act, when you pick it up and begin to study it, what does it give you? When you pick it up, what does it give you? So Mr. Blackburn, when he picks up a law, a piece of legislation, I also would like to tell you that the United Kingdom does not have a constitution. And because the United Kingdom does not have a constitution, Parliament makes law from time to time. That's what Parliament does. It makes law from time to time. So because of that, it behoves on a lot of people to be abreast of the law, to know what the law is saying. And so Mr. Blackburn was one of those people who likes to follow the law. So, and when he is always quick to approach the courts. He just, most times, he will just say, why is the government doing this? And then he goes to court. And of course, he became, how will I say, a parasite at a point, or someone, an irritant to the legal system, because they were asking, Mr. Blackburn, why are you coming to the court to raise this issue? Mr. Blackburn will say, oh, because I have 2 daughters. And so I cannot allow this, to happen. So that's why I have come. So most times, the judges are angry, wondering what, but what Mr. Blackburn was doing at that time, and I will tell us the equivalent of Mr. Blackburn in Nigeria, what Mr. Blackburn was doing at that time was to take justice as an extra legal standard. He really wanted, not on the surface, but to be sure that justice is doing what it is expected to do. That's what Mr. Blackburn was doing. So in Nigeria, a good example of Mr. Blackboard is the late Gani Fawehinmi. Gani Fawehinmi will go to court to question many things. He will even use laws that are in the statute books but are not being implemented. You know, he will also use those laws, you know, to make us see reason. Let me give you an example. When the journalist Dele Giwa was killed by parcel bomb on October 19, 1986, Chief Gani Fawehinmi, because he was Dele Giwa's lawyer, wanted the government to prosecute those who, one, he believed that the government was the one who did this. And then he also wanted the government to fish out his agents that did it. But the government was unwilling. In his own private investigation, he pointed at two people, Director of State Security Services and Director of Defense Military Intelligence, one Mr. Togun and one Mr. Akilu. And he named them, that they are the people behind the parcel bomb. He was able to pinpoint them, but the government was not willing to do anything. So what he decided to do, he looked into the laws of Lagos State. He saw that in Lagos State, there is a provision for private prosecutor. And so he came to the court through that provision of private prosecutor, you know. And of course, the government was caught unawares. The government was caught unawares, and in fact, they had to tell Lagos State to, and since it was a military regime, the president just told the governor, the military governor of Lagos State, to do something to that law. So the attorney general, you know, they had to rest, you know, that law, you know, that law that talks about a private prosecution. That is justice as an extra legal standard. That's one. I also want to give you another example. The other example is a case which I'm sure you must have learned in your 300 level. And it's a case I love so well. I love to talk about it because of the jurisprudence in that case. And if you never read that case before, please, I beg you, I will want you to go to the law report to read that case, which is the case of Nasiru Bello and Attorney General of Oyo State and others. Because in that case, the facts of the case is as follows. A decision of a High Court of Oyo State sentenced a supposed armed robber to death. After the court handed that decision, the supposed armed robber appealed against the decision of the Oyo State tribunal. But while pending his appeal, the state went ahead and executed him. And so his family, they brought an action, a civil action in tort against the state, talking about the fact that their breadwinner was taken away from them. So they brought an action against the state. when they brought the action against the state at the Court of Appeal, because the lawyer that brought the action was an NYC lawyer, and so he didn't feel there were some forms that he did not fill. So the judges in the Court of Appeal threw out the appeal on the basis of that. But he, not satisfied with that ruling, appealed against the ruling of the Court of Appeal. And at that point, the Supreme Court allowed his appeal, because we're talking about justice here, and Court of Appeal was talking about form, And that's why I want you to pick up the Nigeria Weekly Law Report and look for the case of Bello, an Attorney General of your state. In a Supreme Court, in a case of such, as you have been taught in your 200 level, there's going to be several judges. And each, of course, there's going to be someone who is writing the lead judgment. And then all the other judges will be there. I want you to particularly read the judgment of Okuta JSC, as it then was, and Obaseki JSC. I want you to read all the comments of the judges, but I want you to concentrate on Okuta and Obaseki. Why did I say that? Because their reasoning, their logic falls into justice as an extra legal standard. That when we are talking about justice, we don't allow forms at times. We are holding justice, and we want justice to deliver. And so for that, we will be going an extra. We will not sit on just, okay, does this fit the bill? No, we're going to go an extra legal standard. That is why I want us to read those, to read the judgment of those two people. You must read all the judgment. That is all what the judges had to say. But after you've read all what the judges have to say, please concentrate on Okuta and Obaseki. I want to stop now and ask if you have questions before I go to the last lap of this lecture. So do we have questions at this point before I go to the last lap?
Good morning, ma'am.
Morning.
Yes, ma'am. So, my question is that this assertion about justice as an extra legal standard, is it safe to say that it is the rationale behind acts of judicial activism by courts?
Yes, I think we can say that because when we have judicial activism, what exactly we're going beyond the ordinary template. That's what we're saying. And a very good example of judicial activism is the judgment of Nikki Toby, JCA, as it then was, when he made pronouncement on Mojeku and Mojeku, which is a tradition, an Igbo tradition, which was accepted. But when that tradition was challenged, and what Nikki Toby JCA said at that point, was judicial activism, even though he was at the Supreme Court, Obaseki again, being a traditional man, struck down that reasoning of Nikki Toby. But you find that was judicial activism, and that was holding justice in an extra legal standard. Because what is the justice? That if a man has daughters, his daughters cannot inherit anything. It is his brother or his nephew, So those are the issues, that we will always see in the society. So justice should be able to rise, in defense of those who are defenseless or voiceless. Do we still have other questions?
Yes, ma. Good morning, ma.
Morning.
Sorry, please, I have a question with regards to this justice as an extra legal standard to the earlier point you mentioned about Dele Giwa. I didn't really understand it. You said that because it was military regime, the military ruler basically spoke to the military governor of Lagos State to remove the law. So how justice as an extra legal standard?
The fact that late Chief Gani Fayemi was able to use the private prosecutor law of Lagos to challenge the government is an extra legal standard. It's making justice, because the manner of death that Dele Giwa died is not natural. He was killed by parcel bomb. And so, for that reason, the late Chief Gani Fayemi wanted to prosecute those he believed were responsible for it. And the state was not cooperating. The state was not cooperating. And so what he needed to do is what he thought he could do by using the private prosecutor law of Lagos State to challenge the government to bring to book those he believed are in the know of what happened. And the action itself is an extra legal standard, demanding justice. The dead person cannot demand justice. He's dead. It's the living that can demand justice for him. And that's what happened.
Hello, man.
Yes.
Good morning, man.
Morning.
And Happy New Year, man.
Same to you.
Okay. Sorry, man. This extra judicial legal standards, it could tend towards what judges do as a school of thought. Because if we must apply law as it is, but the judge has the prerogative to now deviate a bit from interpretation as law as it is. It means the freedom of the judge's mind comes into play, man.
Yes, but you see, even if the mind of the judge does not come to play, there is a compelling way that the lawyers will address the judge, address his conscience, There is a way, it will address his conscience and make a demand, It will address his conscience and make a demand for it.
Thank you, ma'am.
Yes. So do we have other questions?
Morning, ma.
Morning.
I think this is like one contribution, ma. So I think that this extra legal standard, it's performed by both judges and counsels. For instance, the Gani Fawemi's action in that Fawemi and Akelu directing the state prosecutor to decide whether he wants to prosecute or not, or hand over the case to him. That is for this part of the lawyers. Then for the judges' side, it comes to play in the form of judicial activism. And a very good example would be in the case of Ansom Kuti and AG Fed. The fact of the case are popular, where they threw Fela's mom down and she died from it, the operatives of the Nigerian army. And then in the judgment, I don't know if it was Kade Esho that gave the lead judgment. But then in that case, I remember I said that he had to read through all the constitutions of Nigeria because the case happened around 1974, just before the inauguration of the 1979 Constitution. Of course, when he got to Supreme Court, the 1979 Constitution was in force already, but then the case happened before the 1979 Constitution came into force. And he read 1960, 1963 Constitution, and at that point in time, the doctrine of state immunity from the tortious activities of its servants was still in play. And because of that, he could not find any grounds to hold the Nigerian army accountable for what they had done. And in that judgment, he said it's that sad as it may be, there is no remedy for her whatsoever. And that's why subsequently, after the 1979 Constitution now came into play, Section 17(2)(e) that granted access to courts and abolished the doctrine of state immunity.
Well, that's right. You see, I also believe that the same Kayode Esho, the same Kayode Esho,
Okay.
who is also a master, you know, in judicial activism. If he wanted to do something, he could have done it. But maybe, you know, you never know how his mind was working at that time. Do you understand? So that's the only way I can put it. Because it's the same Kayode Esho that talked about executive lawlessness when
Yes, ma'am. Yes, ma'am.
in Ojukwu and governor of Lagos State.
Yes, ma'am.
This is the same Kayode Esho that talked about So if you wanted to do it, if you wanted to hold justice as an extra legal standard in that, he could have done it, you know. And it's the same if the case of Lakomi and Attorney General of Western State.
Yes.
The same Kayode Esho.
Yes, ma'am.
So, well, unfortunately, we can't ask him why he thought about that because he's no more. But we can say that if he wanted to do stuff, he could have done it.
Yes, ma'am. Like I said, it is owing to that doctrine that was in existence as at then. You know, under the 1960 and 1963 constitutions, the states, that's Nigerian state and government, they still had sovereign immunity. Rex non potest peccari, the king can do no wrong. And it was still in operation because of the 1960 and 1963 constitutions. But the 1979 constitutions now abolished that. And the dates of Lakomi and Kekeloma and Ijo Western States, it happened in 1970. So all of these things happened before the 1979 Constitution. And regrettably, there was no way you could have brought them accountable.
Of course, the governor of Lagos State issue happened much later because Ojukwu was granted pardon and he came and he wanted to access his father's house.
No,
it's in Ikoyi.
Yes, Ikoyi, sorry.
It's in Ikoyi. It's in Queen's Drive now in Abayomi. So, and they said it's an abandoned property and so on and so forth, you know. But the fact still remains that for me, if they wanted to do anything, they could do it. But I think we shouldn't stop flogging that, because even now you cannot, governors have immunity. You cannot, even now, you can't take a governor to court for, for any, for any act he did while he's as a governor. You can't take him, so
Yes, yes.
so that's just
Thank you very much, ma. I understand, ma.
okay. So do we still have other questions before I go?
Maybe a comment, man.
Please, I have a
Okay.
question, ma.
Maybe a
Please let
comment,
the
man.
question ask first.
Okay,
Prayer?
man.
Yes.
Okay, good morning, ma.
Morning.
So the question is based on the Gani Farm vs. Akilu case, where he said Gani was basically directing state prosecutor to either actually, in quotes, do his job. So my question is, why does this concept of the law, the concept of justice as an extra legal standard actually look like we're actually trying to make the government actually do their job? Like, in a way, it's extra because somebody doesn't want to take the particular lackadaisical norm as the way and actually fight for what should actually be done. I don't know. So that's my question, man.
Justice as an extra legal standard is not only limited to state activity. It also can be used for private prosecution or even for a community. Take, for example, if you've read about SERAC and the government of Nigeria, and what's the facts of the case? There is oil spill in Ogoni land, and Ogoni people want the government to stop doing what they're doing, and government, and then they sued the government when they saw that the government was not responding. And the government responded by saying, look, in Ogoni land, we can, that is where we get our remuneration, this. No, the court said, yes, you get your remuneration from Ogoni land, but you could do your activity in Ogoni land in such a way that it will not impugn the livelihood of those people who live in Ogoni land. So you cannot say because that's your only revenue, you have to embrace what is called sustainable environment. You have to exploit the environment in such a way that generations yet unborn will still have access. Not that you want to exploit the environment and then you destroy the environment, you exploit it, and the environment is no longer useful for those who, So that is an extra legal standard. That is justice for you. Say that you need to go beyond a certain way it's demanded of you. Is that, are you clear now?
Yes, ma'am. Thank you.
Okay.
Hello,
Okay.
man.
Yes.
The comment I wanted to just make is to add to the discussion of judicial activism. In the case
Okay.
of Wole Soyinka, when he seized the radio station in the Western region then,
Okay.
it was the same Justice Kayode Osho as he was then, that also got him freed using the process of judicial activism.
So that's why I said that if he wanted to use judicial activism when he wanted to use it, he could have used it. You understand what I'm saying now?
Yes, man, I understand. Thank you, man. Okay.
So let's move further. So we're going to law, justice, and jurisprudential antinomies. What are those words? When we talk about law, there's no way we talk about law that we don't talk about justice. because there will be no use of law without justice. There will be no use of law. So when we talk about law, we also talk about justice. We will say that this is what is expected, you know. We say this is what is expected. So we say that this, if the law has been broken, this is what is expected. Then we also say that law can be used, you know, because you find that law, as they say, is an ass. It can be used in both ways, you know. Law can be used in both ways. You can use law positively and you can use law negatively. So when we're now talking about jurisprudential antinomies, we're talking about things, you know, that don't add up, you know, that when we look at it, they don't add up, you know. But, and at times you find the courts oscillating, you know. They have said some things before, and they are now saying another thing, you know. They've said some things before, then they may now say they are having some rethinking or something like that, you know. So you begin to wonder, what is the rethinking about? You know, what are they rethinking? You know, so that's so those contradictions, you know, because we could find contradictions, and even in this class we've demonstrated a little bit of contradictions using a particular jurist who gave some judgments in a certain case that you can see this is judicial activism, and the same person is saying something else, you know, in another case. So you can see, you know, those you can see the contradictions, and there's so many contradictions when we look at law and justice. A very good example is when we are talking, you know, let me go use a bit of the Nigerian state. In our constitutional law class, we must have had of the story of, how do I call it? We must have had of the two thoughts of 19 states, you know, which is, they say is 12 two thoughts. There have been a lot of jury on whether that decision was correct, you know, whether two thoughts of 19 states is it's 12 two thoughts. And of course, it seems like the 1999 Constitution, learning from that, have tried to help, but it has also not helped. Why did I say it has also not helped? Because we also now have the situation of you must win Abuja, and you must win Abuja and one other. No, if you want to win presidential election, you must win. Abuja is one of the things that you needed to win. And we find that in the concluded election, I'm not too sure whether the tribunal was really able to address that issue the way people wanted. So you find that there is always contradictions in law. There is always contradictions, you know, and this is why the makes at times the average citizen not to like lawyers. And you find the average citizen say that lawyers are liars, and you find an Englishman who said that if they want a sane society, they should kill all the lawyers, you know. So you find such things being said, that you want a sane society, just kill all the lawyers. If you kill all the lawyers, then our society will be okay. Do you understand? So these antimonies, and not only does it, at times, not only does it make people to lose interest, you know, in law, but it also at times you find, I wouldn't call them criminals, but you find people who are angry at the law, you know. You find that they justify, they justify their anger, based on the fact that there are contradictions in law. Let me give you one of those contradictions. The federal character issue, and I want to take you back to your 200 level, Badejo and Minister of Education, So you find that everybody has written common entrance to go to federal government colleges. We say we're doing federal character, and this federal, in order to have a balanced equation, some folks are not given the opportunity. Let me use that word. Because Badejo is from Ogun State, saw that her classmate that is from the northern part of Nigeria was able to get admission to QC, and she from Ogun State could not, and she scored far higher than that classmate. That is a jurisprudential antinomy. How do we explain that when we say justice? When we look at justice as treating like as like. So how do we explain that? So those are the issues, that often comes up, when we have this kind of problems in the society. The society is trying to balance, society is trying to balance, and it seems that the society is, while it's trying to balance, but it's also incurring, a contradiction. So how do you pacify Ms. Badejo? So these are contradictions, that we see in society. So oftentimes, we find that this kind of issues, really do affect folks. It does affect citizens, and and they're worried, So those are the issues. I'm not sure whether I have communicated, but if I've communicated, I would like to have your questions, if you understand what I'm trying to put down, I would like to have your questions.
Please, I have a question, ma.
Go ahead.
Please, I'm trying to understand the example of antimony you gave. Are we saying that basically contradictions? I don't know if you just explain the example again, or probably another example, ma, for the antimony.
There are always contradictions in society. We can't rule that out. And I gave you an example of Badejo and Federal Minister of Education, a case which I'm sure you must have had when you were in 200 level in constitutional law, when we're talking about right to education, but we can also use it in our jurisprudence class because we're looking at a standard that has been set. Write exam, you must score this, and because of federal character, someone did not score, and yet that person is given admission over someone who scored above that, and it does still happen. Right now, we've concluded admission process for post-UME and all that, and some people, they did well, but they cannot come in. Why? If they miss merit and they are not in catchment area of University of Lagos, they may even have scores that are higher than catchment of University of Lagos, and they will not come in. These are antimonies, because of this federal character thing that we're talking about. These are contradictions. We're talking about justice for all. We're talking about access to education for all. And yes, within that, we're having a situation where some folks qualified, yes, on the face of it, but will not be able to have admission. So those are the issues.
All right, thank you.
Okay. Does anybody else have questions?
No, man, no, not a question, but maybe addition as a comment, man.
Okay, go ahead.
Well, the antimony also, I think it may not strictly be a legal issue because these are policies to enhance, maybe address situations in the given society. In the case of Badejo issue and comment trans and co, I think it's generally perceived, well, people wrongly, that people from the other part of the country are educationally disadvantaged. So those provisions are made to address the disadvantaged situation of our citizens. But except for the 12th to 3rd, the Awolowo versus Shagari matter that was subject to judicial interpretation. And like you said, ma, in the very last 2023 presidential election, the tribunal did not actually address the issue of FCT, whether it was a conjunctive or adjective that the presidential candidate must win the FCT election for it to become a president.
So
those are my comments, ma'am.
Okay, beautiful. Because you find out that this is where we have issues, and another issue which is also very germane, which most times really does get to me, excuse me, is the issue of Kudirat Abiola. It's common knowledge that Kudirat was assassinated. The Lagos state government went to court, to prosecute. There will be people that took part in the assassination. But you see, nothing came out of it. We had motions, but at the end of the day, nothing came out of it. So these are because we'll find out that Rojamila that had spoken, that had said that this, that, eventually recounted, so, these are issues, so that makes us most times, and that's why those who say kill all the lawyers, why you may not agree with them, but you will find that truly some things do happen, and he makes people to lose, they lose, they just lose their, they just feel, oh no, I can't, I can't continue like this, but what can we do, in such matters when it's not done, what can you do? So those are the issues, and we see that come up many times, we see it come up many times. So we've it's a very hard place, let me use the word, especially when justice does not deliver, when people expect it, that there is a certain way that the average man perceives an issue, and when the law court, looks at the letter of the law and does not go the way, the rationale, the emotions of the average people. So what do you say? Say, for example, the NSAS protests, and the government set up some form of a panel, but nothing has come out of it, And so, so we can go on and on and on, to say some of the contradictions that happens in the society, that law at times too may be powerless, because I, for one, as a law in development person, always know that law does not have answers to all issues. Law purports to, law claims that she has an answer to every issue. But we say, no, she doesn't. She doesn't have that. That's what she thinks. Because, and a good example, if you don't like someone, law cannot make you to like the person. It's not possible. You don't like the person, fine. All law will do for you is that you should not discriminate against the person. That you don't like the person, law cannot enforce you to like the person. So these are contradictions, and yet law will always say, no, I'm the father, I'm the mother, I can do this, I can do that. But it's not always so. So you find most times that law cannot deliver all she thinks she can deliver. So do we still have questions before I do a summary of what we have learned today? Do we have questions?
It's not a question, it's a comment to what someone said earlier.
Okay.
So he mentioned something and he stated disadvantaged states. So let's say to an extent, the educational system there is not as good as here. But then that should not, creating like a lower standard for the term disadvantaged stage shouldn't just be the only solution. Fine, you might give them a quota, but are you focusing on the actual problem, which is the education system? they should also work on making the educational system better, not just giving a quota for disadvantaged states as they term them to be.
Okay, this one that you have said is a policy issue, is a government issue. Well, the federal character has caused a lot of people frown against it, and a lot of people complain against it. But you see, I agree with you that should we continue to pamper? I think that's the word you're trying to use. Should we continue to pamper these people, or should we do stuff that will bring them to be at par, with everybody? I think in a way it's a measure of what we call what they call affirmative action in America, which you try to bring those who are disadvantaged, at par, because if you concentrate on merit, some of these people may not be able, to make it on merit. So they're being given, they are being given that opportunity. Well, I hope we will get there at a point where every segment of the Nigerian state, we believe in the power of education and will not see education at times as a ploy of slavery, or as a ploy of being taken advantage of. I hope we'll get to that point. So thank you, Balikis. Do we have other questions? If we don't have other questions, let me try and do a recap. Today we talked about law, order, and justice. We defined those concepts. And of course, we're already conversant with those concepts, at least from our legal method class. And then we went on to talk about how justice has an extra legal standard, because there is a standard for justice, but we go beyond that standard and demand an extra one. And we agreed that one of the ways we've come to that one is through judicial activism. And we were able to discuss some jurists who used that portion. And we also had cases. We also talked about cases where we used, where those jurists were able, to focus on those stuff and give us an extra legal standard, to hold the community or to hold the society accountable and for what they needed to do. Now, we go past that. We go past that to now talk about justice and its jurisprudential actimony. That is, those things that form contradictions, they form contradictions, they form contradictions. And because they form contradictions, it's really, really, really tough, because they form contradictions. So it's very tough, because they form contradictions. And we often have questions. We often have questions when we get, but some of these questions may not be resolved and they are not resolved because of the contradictions within the justice system, you know. And like I said, that is why you find laymen saying that kill all the lawyers, you know, get rid of them, you know, but that will not solve the problem of contradictions. But as lawyers or lawyers in the making, we strive to see that there is justice. And this justice is to the victim and to the defendant. The justice is not only for the victim, but also to the defendant. Both should see that justice has been served. Although in most cases, justice focus on the victim. It doesn't focus on the defendant. So in all, our society can only thrive, and we thrive when we have justice. You know, our society can only thrive when there is justice. When there is no justice, our society will not thrive. So it's justice that makes our society thrive. So, and in the absence of justice, our society will not thrive. So we seek a society. So for us now, we seek a society that will make us thrive. And that society will be a society that is placed on law and justice. And when we look at the picture of the Lady Justice, it's blind and the scales are even. That is the desire of most people in the society, that when this justice is going to be done, you know, it's not going to show affinity for one person more than the other. So on this note, I'm going to end the class, but I'm still open to a question because we have 5 more minutes.
Okay, ma, can I ask this question now?
Go ahead.
Sorry to bother you. You know,
It's
we're
okay.
almost becoming lawyers, but I try to explain the symbolism of a lady because you raised it now. Why is it a lady that is used as a symbol of law?
Hey, this is a very, you know, this law we are dealing with, it's English and Roman law. There are myths associated with that. And women are seen to be virtuous. Women are seen to be truthful. Women are considered as people you can rely on, you know, and that's why that symbol is used, you know, to show, you know, that it is only women that can deliver, you know. Know that in those times, in those times, you find that women were not at the echelon of the society. Women were underdogs. Women didn't even really have a personality. Women and children are lumped together. So they tell us that it's only women, you know, who can do certain things, you know. So that's it.
Thank you, man.
Okay.
Thank you so much, man.
Okay. Do we have other questions? You should feel free to ask. We have 3 more minutes. If we don't have questions, I'm going to end the class and we will meet again on Wednesday. So see you on Wednesday.